This provision was added after the case judgment of Indra Smane versus Union of India. A landmark in the issue of reservation was the judgment pronounced in this case by the Supreme Court, which follows. In the year of 1979, these are the facts of this case, that Prime Minister Shri Morarji Desai appointed the second backward classes commission under Article 340 of the Constitution. The commission was headed by B.P. Mandal, and its mandate was to investigate the status of socially and educationally backward classes in India. When the commission finally submitted its report in 1980, it recommended a reservation of 27% in government jobs for these castes. The collapse of the Janata Party government complicated matters, and the recommendations of the report could not be implemented. There wasn't much progress in the respect of several years until Janata Dal gained power in 1989 after the lapse of 9 years, and decided to implement the recommendations of the report and reserve 27% of the seats for socially backward classes. This was followed by reservation and anti-reservation protests in large parts of the India, which led to riots. When the government actions was challenged before the Supreme Court by the way of writ petition, the then Prime Minister P.V. Narasimha Rao brought in another order which increased the reservation limit to 37%, while including economically, socially and education backward classes as well. The 5-judge bench referred the matter to a 9-judge bench, and the issues was raised there. After a lengthy discussion, the bench believed that caste can be considered for detecting social class. If a class is backward socially, it would be considered a backward class for Article 16(4). Neither the Constitution nor any law provides yardstick to identify who qualifies as a backward class, who doesn't. The court relied on the decision of Devdasan versus Union of India, where the court held a 50% cap on the reservation. After the it also ruled that Article 16(4), Clause 4 of the Constitution only granted reservation for the initial stage of employment. In terms of promotions, no reservation can exist. It can only solely in terms of merit. But later on, by the Constitutional Amendment 16, Clause 4(a) was added, according to which the promotion on the basis of reservation can be provided. And it also mentioned consequential seniority. To understand consequential seniority, let us assume that A belongs to a general category, currently holds level 3 of a government post. B, appointed under the scheduled caste quota, is junior to A in level 3. When promotions to level 4 are to be decided, let us assume further that due to reservation in promotions, B has to be promoted to level 4 because before A, there are no scheduled caste candidate at a seniority similar to that of A. The question that then arose was whether A would regain seniority over B when she is promoted to level 4 in due course. Consequential seniority means that A will not regain her seniority and B will be considered senior to A within level 4. When A will be promoted to level 4, he will be not having the seniority. He will be has been promoted by the quota will be considered as senior, even when A was his senior. And later on, according to Clause 5, nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. That according to this article, it will not be applied to those situations when the post requires a person of particular religion. Just suppose a post for a priest in a temple. The religion matters there. Only a particular person from that religion could understand that religion better. So the priest of that particular temple will belong to a particular religion. And according to 16 clause 6, nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any economically weaker section of citizens other than the classes mentioned in clause 4, in addition to existing reservation and subject to a maximum of 10% of the posts in each category. According to 103rd Amendment Act 2019, this clause was added, according to which there will be 10% reservation for economically weaker section, which was similar can be seen in Article 15, that reservation for EWS, the economically weaker section, was given.